Now on to page 3. We're still in section 4, and 4.8 discusses that the seller is going to pay for the costs of the closing documents on their side and to discharge any caveats and mortgages and so on. And under 4.9, the buyer is going to pay to prepare, register, and discharge the buyer's caveat based on the contract and to register the transfer of land. 4.10, if the property is rented and the buyer is not assuming the tenancy, then the seller is responsible for all costs related to ending the tenancy and to giving vacant possession to the buyer. 4.11, as part of those normal closing documents, the seller will provide the buyer, in regards to the matters in 6.1, a real property report reflecting the current state of improvement on the property according to the Alberta Land Surveyor's Manual, and it should have evidence of municipal compliance or non-conformance. This obligation will not apply to any transaction where there's no structures on the land, where it's just bare land. And then finally in 4.12, notwithstanding the closing provisions in the contract, the parties instruct their lawyers to follow, if appropriate, an Alberta conveyancing protocol. In other words, where the funds may not have gone across from the buyer to the seller, however, using that protocol, the property can still close at that specific time. Now under section 5, this is saying that the seller needs to have insurance on the property so that the risk of loss or any damage lies with the seller until the purchase price is paid in full. And then of course something does happen, the proceeds would be held in trust for the buyer and the seller according to their interest in the property at that specific time of the occurrence. Now in section 6, it's really important to read through this and know what's going on here. The seller is representing to the buyer and warrants that, first of all, the seller has the legal right to sell the property. B, the attached goods and the included unattached goods or fixtures, they're all in normal working condition and they're free and clear of any encumbrances. C, the seller is not a non-resident of Canada for the purpose of the Income Tax Act. And the current use of the land and buildings complies with the existing municipal land use bylaw. And this is important to make sure that the home as represented or the building as represented does comply with the existing municipal land use bylaw. If it doesn't, then the seller is not warranting or representing you properly as the buyer. E, the buildings or the other improvements like a deck and so on are not placed partly or wholly on an easement or a right-of-way. They don't encroach on the neighbors except where there's actually an encroachment agreement that's registered on title, or in the case there's an encroachment on the municipal lands like a back alley or a right-of-way, the municipality has actually endorsed the encroachment and it's applied directly to the real property report. Next, under F, the building and the other improvements that are on there comply to the municipal bylaws, regulations, or, matter of fact, any relaxations prior to the closing date. Or, if the buildings don't do that, they are non-conforming. And the current use of the land and the buildings and the location of those buildings and any of their improvements comply with any restrictive covenant on the title. And finally, except as otherwise disclosed, the seller is not aware of any defects that are not visible and that may render the property dangerous or potentially dangerous to occupants or unfit for habitation. So that's very critical, especially when you're looking at properties that may have been a grow-up or have mold in them and any other issues from radon and lead paint and so on. So that one's critical to look at. Now there's a good possibility under 6.2 that there's going to be either warranties or some other schedules attached to the purchase contract, and those will all be true at completion date. Under 6.3, any of the representations and warranties in the contract may be enforced after the completion date, provided that any legal action is commenced within the time limits based on the Limitations Act here in Alberta. And under 6.4, both the buyer and the seller acknowledge that there's no warranties, representations, or collateral agreements made by or with the other party, with the seller's brokerage, the buyer's brokerage, about the property, any neighboring lands, and this transaction including any of the warranty representation, including relating to the size and measurements of the land and the building, or the existence or non-existence of any environmental condition or problem. So both parties need to acknowledge that. Now under 7.1, the additional terms. So all terms are going to be Alberta time. The 7.2, the contracts is for the benefit and is binding upon all heirs, executors, administrators, or other assignees of the individual parties. And all changes in the number and the gender will be made where required, usually by a separate addendum. 7.4, the contract is governed by the laws of the province of Alberta, and that anything occurring would be held in the courts in the province of Alberta. 7.5, occasionally there's other additions to the contract that would need to be added, and you can check them off or put in other additions in there, like a financing schedule and so on. And finally, under 7.6, additional terms of sale, if any, and there always seems to be some, add that in there. And since we're using usually email to transfer documents back and forth, it's a good idea to put in here that email transmission of this document is acceptable and binding for both the buyer and seller. And of course, both the buyer and seller agree to that. And again, there's a spot there for the buyer's initials on page 3.